Good morning. It's Friday, September 12th. And there's always something going on in this country to talk about. So this morning I'm going to talk about something that the Supreme Court has taken into consideration. And the question that we have to answer is, did the Supreme Court just okay racial profiling? Were immigration and customs enforcement agents violating people's constitutional right when they swarmed the car wash in Los Angeles wearing masks with no identification and rounded up people without asking for IDs? The Constitution bans searches and seizures that invade people's privacy. Legal experts say it applies to anyone in the United States, regardless of immigration status or perceived immigration status. Two lower courts said that ICE likely detained people based on race. If you're an ICE agent, you need reasonable suspicion to search someone. And we all agreed to that, said Jessica Levinson, a professor at Loyola Law School in Los Angeles, and the host of the Passing Judgment podcast. But the Supreme Court ruled this week that ICE was likely within the law and allowed agents to continue using race as a factor in immigration raids. The justices didn't rule on the merits. That could come later. Justice Brett M. Kavanaugh offered some explanation for the ruling. To be clear, apparent ethnicity alone cannot furnish reasonable suspicion. Under this court's case law regarding immigration stops, however, it can be a relevant factor when considered along with other salient factors. I don't understand one word of what he's talking about, but I think he means that race can be a factor. Color could be a factor. Age might even be a factor. Who knows what these people think is important when they're about to raid someplace. What Kavanaugh is saying is, if you look at the totality of circumstances and the number of people who are in Los Angeles and not here with proper documentation, it's enough to say that race and ethnicity plus something else. Are you speaking with an accent or in Spanish? Where you are in the city and what work are you performing, Levinson said. And Sotomayor is saying that's not enough. She is saying you get to round up people based on the color of skin and the language you're speaking and where they're situated, and that's tantamount to racial profiling. The Supreme Court's ruling is a different reading of the law from how Jeremy Vogel, a former judge who now heads the Berkeley Judicial Institute, understands it and applied it when he was a judge. Now, applying our laws can be very difficult. The wording is extremely difficult to understand for a non-lawyer or a person with average intelligence. There's long-standing Supreme Court precedent that to deprive somebody of their liberty, even briefly, you have to have something specific about them. It can't just be he looks like he's a Latino and he's speaking Spanish and he's working at a car wash. That's generic and not specific to an individual. So they're saying you really have have to have evidence. And who knows what evidence really means? Can the way you dress be considered evidence? Can the amount of intelligence you have? Can evidence be the fact that you don't speak English? Who knows what could be considered evidence in a raid? So it's crazy when you consider the situation in this country and the fact that we have immigrants and we have many people in this country illegally. But it's extremely difficult to point at somebody and say that person is an illegal immigrant. And you can see by these actions that were taken by law, by people supposedly representing the law, that the fact is not very clear about who's here legally and who's here illegally and how to identify them quickly on the spot. So I leave you with that. Immigration raids that are not perfect. They cannot be perfect. And so if you do it, you have to be careful not to impose justice on the wrong people. So have a great day. Think about it. How would you handle this situation? Take care. Bye.